I believe that Mr. Martell would like to start us off by motioning for Your Honor to recuse himself from this case.
Judge, if I may, very briefly.
Go on.
Thank you, Judge. And certainly, Judge, I got much respect for this honorable court, been before this court a number of times. Judge, but the court rule is clear, Judge, that a examination must be conducted by a neutral and detached magistrate, Judge. In this particular case, and just for a little bit of context, for Your Honor, this is a case where there's already a co-defendant, where an examination has been held, where the testimony has been taken, where the victim or complainant absolutely identifies a mixed race, ethnicity, light-skinned male, certainly not my client who's dark brown skin with barrel rolls. Judge, notwithstanding saying, Your Honor, did the sole basis that the people intend to introduce quote-unquote identity is through the search warrants and the subsequent evidence that was purportedly obtained thereafter, Judge. I say that all to say that, Judge.
I don't know what case you're talking about. Who's the co-defendant?
You didn't preside over that. I could make the argument a lot more.
I did not preside over it?
No. So the argument that the counsel is attempting to.
Well, then I'll let him finish, because I don't know. It did not even begin to ring a bell with me.
It shouldn't.
But if I can just streamline it, Judge. In brief, Your Honor was presented ex parte with 2 search warrants in this particular case. Ultimately, these 2 search warrants, there was information heard, there was a search warrant, there was probable cause found, there was search warrant signed. Judge, we now come before you for a separate analysis of whether there's probable cause in this case, but Your Honor, pursuant to People Be Real, which is 391-124, Judge, it certainly cannot be neutral and detached when Your Honor respectfully has already found probable cause in this case. And specifically, the case law says.
Whoa. How the hell do you jump to that conclusion? Because the probable cause that's determined from a search warrant is based upon that evidence that is presented to me in the form of an affidavit on that search warrant. That's going to have no bearing whatsoever on what testimony I hear or don't hear in this case. So I don't even know how you get to that conclusion. But I'll let you continue, because I think it's a... Go ahead.
Thank you, Judge. And Judge, just certainly to preserve the record, certainly I don't want to come back on a quash or an appeal or even a remand, Judge, but the case law is clear. It says that the defendant requests a magistrate other than the magistrate who has already heard ex parte witnesses, such as the request should not be or should be regarded as reasonable and reasonable efforts exerted towards compliance, Judge.
What ex parte witnesses did I hear from?
Judge, Your Honor signed both of the search warrants in this particular matter. Certainly testified.
But that says I've heard from witnesses. I've not heard from any witnesses.
Judge, so if it's your position,
does that case clearly apply to search warrants?
No.
That it's not limited to search warrants.
But that isn't what I asked you, Mr. Martell.
Yes, Judge.
Is that applicable? I could certainly see a circumstance where I would have heard, like what you started out with, which doesn't seem to be true, that I heard something and then there would be a request that I not hear it because I've heard the witnesses or testimony. And so in that circumstance, there would be a much different analysis. But now you're trying to cite a case, apply it to something that I don't think that applies to.
Judge,
just by the very words that you said. And certainly you show me that it says that a judge that has, or a magistrate that has signed a search warrant should not then hear the preliminary examination where they've made a finding.
Judge, specifically this relates to an arrest warrant, not a search warrant. However, if it's the position of the court that Your Honor has heard no testimony, sworn testimony or otherwise, then I guess our request would be moot. But
I have read, so that we're clear, because you're playing fast and loose with words. So that it's clear, I would have read the search warrant. I don't recall receiving any testimony at all regarding that search warrant, because I typically don't. I make a determination if there's probable cause contained within the 4 corners of that document, swear the individual in, sign off on the search warrant. It's really as simple as that. So if you show me a case, Mr. Martell, that says under those circumstances the court shouldn't hear it, then show me the case. Otherwise, you're wasting my time.
Judge, so acknowledged, I would say that Burrell is applicable, and I would also humbly submit, Judge, that the position of the court that anything outside the four corners of the exam transcript has been analyzed or sworn to, then it would certainly fall.
Then you're going to need to file a motion so I can, if it doesn't bear out, I can find it frivolous and I'm going to adjourn this and then I can sanction. You need to file a written motion. How long is that going to take you?
Judge,
How long is that going to take you?
Judge, certainly.
How long is that going to take you? If you cannot answer that question, then I will take a recess. I will give you time to think about that. And then I will come back and I need your time frame for how soon you can file the motion. In fact, why don't we just do that?
We're prepared to proceed.
Why don't we just do that? You can take him back. Court's going to stand in recess.
All right. And good afternoon once again, Your Honor. Good afternoon to your fine staff. And please, this most honorable court, Edward Martell, P 85051, on behalf of Darren Dwayne. Please state your name once again for the record.
Have a seat. So, Mr. Martell, you know, I'm a bit concerned. I just take what people give me. But I'm just going to say this. You lied to me at the very beginning of your argument. I went back, had my staff go back. You said that I held a preliminary examination on the co-defendant. I couldn't recall it, but it's not true. That was an absolute falsehood and misrepresentation to this court. Ms. Hughes then points that out, but I'm still not sure. On the break, I go back, have my staff look it up, which was some doing, but if the case that you're referring to as a co-defendant is Christopher Harrison, that case number for reference is 24F22251, our case number. That is not the circuit court case number. I didn't handle that exam. Judge Barr handled that exam. So your initial argument regarding recusal started with and I hate using the word, but it's true. It started with a lie. Then, Mr. Martell, you continued with your lie regarding the import of the case of People versus Burrell, which you cite one portion of it about a magistrate who takes testimony and does that. And that's why I went through exactly what this court does regarding search warrants. And then you cite a portion of that, and I think intentionally skipped over the first part of that paragraph to mislead this court. And I'll tell you what it says. It says, whereas here, an affidavit presented to a magistrate was in conclusory form, which I'm sure those search warrants were, and did not state any of the underlying or operative fact, and no witnesses were examined, which they weren't, we can perceive no prejudice to the accused in having the magistrate who issued the arrest warrant, which is different, preside at a preliminary examination.
If I may.
If it's not going to be a lie, go for it.
Judge, respectfully.
No, you lied to me.
Okay, if I may, Judge, very briefly, I think the record will reflect it. When I cited or spoke about a preliminary examination, I didn't speak directly as to this court having held it, but it having been previously held. I was not present at that particular examination. However, Judge, certainly I would make no false representations as to who held it or who didn't hold it. I think I just provided that for context.
You want me to play it back?
Judge, I certainly do not. But
you want me to play it back?
Judge, I certainly, if Your Honor, some other time wants to, that's fine.
No, if you're going to sit up here and tell me you didn't lie to me, you want me to play it back?
Judge, then I stand corrected, Judge, but I certainly intend to make no misrepresentations of context. The main argument is what it is. And certainly Your Honor is not barred from presiding over this exam. But again, and I've spoken with my client in the basis of just preserving the record and putting forth this argument, certainly mean no disrespect, harassment, or delay to the people. Judge, we're prepared to proceed. If Your Honor intends to deny, that's fine. Again, we're prepared.
I don't know what your motion is, because everything that is presented to me is not it. Ms. Hughes, do people have anything to say regarding this?
I have quite the record to make regarding the one thing that I absolutely have to say, even though I think this argument is clear and where this situation is headed is clear, but the thing that needs to be abundantly clear, I do have a lot to say about the law and I do have my own cases to cite, but if Your Honor doesn't need those, I'll set that aside. But the thing that needs to be said is the search warrants that Your Honor reviewed are what led to the pertinent testimony today. They did not include the pertinent testimony that would be heard today. Your Honor signed off on search warrants that include facts that frankly are not being contested. The defense is not contesting that these crimes occur. They are contesting the defendant's identity. The search warrants led to evidence of the defendant's identity, facts that Your Honor has never heard before, which is where we're about to go. But frankly, the law that I'm choosing not, maybe I just need to, the law is actually clear that a judge who has reviewed and approved a search warrant, even on facts that they will later hear, that is okay, that procedure is okay. And specifically, I turn to People v. Cameron, which is an unpublished case of the Court of Appeals from 2013, and Cameron is Cameron. And in that case, not only did the judge review and approve the search warrant, but that judge went on to be the trial judge, a bench trial judge. And the Court of Appeals said in that case, so the issue that went up to the Court of Appeals was the defendant was claiming that his trial attorney was ineffective by not trying to recuse that judge. And the Court of Appeals said, failing to advance a meritless argument or raise a futile objection does not constitute ineffective assistance of counsel. That is what the Court of Appeals said about trying to recuse a judge who has previously reviewed a search warrant. The other case that is specifically on point is a much older case. It's from 1971. It's People v. Pitchford, 3-3 Mish at 299, 1971. In that case, the defendant actually, at the preliminary exam, wanted to attack the search warrant that the judge approved. And that judge that had approved the search warrant at issue went on to be the preliminary examination judge. Mind you, on appeal, it wasn't that exact issue. It was more of a statutory interpretation issue that went up on appeal. But the Court of Appeals in that case said the statutory interpretation would have led to the same procedure, that the search warrant judge would have become the preliminary exam judge, and then they affirmed and the case went back down for exam. But in that case, we don't even have a case where the defense is trying to say that Your Honor inappropriately approved the search warrant. And we don't have a case where the defendant is even trying to contest any of the facts that were in the search warrant. Sorry, from having nothing to say, I always have a lot.
No, that's fine. Anything else, Mr.
Just very
Martel?
briefly, and I certainly respect this.
Because I'm going to tell you that, quite frankly, Mr. Martel, one may have to convince me why you have not, only in terms of your misleading of this court, attempted
motion backfires
to try to have this judge recuse for the purpose of forum shopping.
Absolutely.
Because, I think so. Because originally I had to step into this case, and I can tell you, you probably weren't necessarily real excited about it. But that's the way that the system works here. And so I think you're continuing on with that. And because there's no other reason, I think, to try to bring this frivolous argument.
Judge, respectfully, I certainly enjoy practicing before Your Honor, and I certainly had no intent to mislead this court, or in fact, before the exam or the transcript thereafter. As far as I don't believe any misrepresentations were made to this honorable court, Judge. I stand firm on my word. At the end of the day, I think there's a basis for our argument to put forth. If it's the position of the court that it's not, certainly, Your Honor, we will move forward with your denial, and we're prepared to.
I have not ruled. You will hear my ruling loud and clear.
Yes,
But do
Judge.
not presume that I'm going to deny it. Before I stepped off the bench, I asked, and I think properly so, your motion should be in writing. How long will that take you to do? If you won't answer me, then I will set the time frame.
2 weeks, please, and thank you, Judge.
Defendant's motion to recuse would need to be filed by December 10th. Prosecutor will respond by December 20th. I will hear the motion on December 26th. This exam is moved to December 26th, 2024 at 12 noon.
Thank you, Judge.
Just for scheduling.
Yes, go ahead. No, that's fine.
I am not available on December 26th. I am
That's-
the person that will be filing the response. I would love to be the person to litigate it as well.
Understood. Then preliminary examination, since this is not of the people's doing, and the defendant, by raising it as well as before, has waived any time requirements, the preliminary examination as well as hearing on the motion will be January 2nd
Thank you, Your Honor.
at 12 noon. 12 noon. Thank you.
Thank you.
On continue.
I'm Stein, the living man. I'm here by special appearance to address this matter.
I'm sorry?
So I'm Thomas Styron, the living man, not Thomas Gilbert Styron, the entity you know me as, or as I'm on the papers. I'm here to address the matter.
All right. Thank you. Wish to be represented by an attorney, sir?
No, I'm here to address the appropriate persona.
All right. I do have to advise, so you're going to represent, you need to stand in the middle of the podium where he's telling you to stand. Now. Mr. Allen. If you don't want to cooperate and
I'm
handle
behind the
things,
podium.
he wanted you in the middle of the podium where you're supposed to be. If you don't want to be there, then say no. I'm telling you now to do it.
If you want me to stand close to the mic, no problem.
Sir, you want to play a game with me?
No,
Not today. Mr. Allen, take him. We'll bring him back out when he wants to cooperate. Yeah, I need an interpreter for the last two and that one.
May I swear the interpreter?
Yes, is it for the last two cases?
Yes.
Yeah, that one we'll swear in.
Your interpreter, you're in front of the Honorable J. Cedric Simpson out of the Board of Canadian District Court of Washington County, State of Michigan. Our number is 1.
Get somebody from security to check back there. I'll take the cuffs off. I don't know that we're gonna be doing all that, but, let me ask you something. On the Styron matter, I sent my bailiff back to get him to bring him back out. The court is of the understanding that defendant number one is being, I will say, uncooperative, has purposely done some things to make it difficult to bring him out. What I'm going to do at this point in time, we're not going to wait and not going to play his game. We will hear him next week because of his behavior today before the court. At this point, I will revoke his bond and I will adjourn the probable cause conference. He certainly poses a risk to even bring him out. So I will adjourn this out to May 2nd, 2024, 9 a.m. or as the invite indicates. I will leave it there for the reasons that I've stated on the record. Mr. Mansour, he is not represented by counsel. If you would, for the court, take the opportunity to come back and to apprise him that of what the court has done and that I will see him next week. The court feeling that he's being uncooperative and not compliant. All right. Thank you.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Tariq Day.
I am Tariq Samar Tariq Day, the executor of the Tariq Samar Tariq Day Living Trust and the registered owner of the Tariq Samar Tariq Day Ex Relatione Kingdomon Wilson Estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the 3rd degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or a $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend, yes.
The court has to further advise you that if you wish to be represented by counsel, the court would ensure that counsel would be appointed to represent you in this matter, and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant to me. I am indicating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role.
How what?
How religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the governments should.
Sir, you have no authority for what you're about to state, because what you're about to state is incorrect.
Oh, I am an Indigenous person.
No, sir, what you're about to state is incorrect.
Refusal to cooperate costs bond. Authority wins.
Well,
If you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter on that is mine. We are not on indigenous lands subject to indigenous or tribal rules.
Is there a
You are
law?
subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency, if, the prosecution, as well as the court and the officers agree to take a competency.
That's not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this
Yes, sir.
because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
Yes, sir.
are you going to cooperate and attend that interview?
Under threat, duress, and coercion. Yes.
Pardon?
Under threat, duress, and coercion. Yes.
No. It's not how it works.
I don't.
I'm asking you, are you voluntarily going to cooperate?
I say yes.
Pardon?
I mean, under it, yeah. I mean, is this what are, excuse me, what are you relaying to in regard? What are you insinuating in regards to where I will stay for a time?
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse me?
I will take the interview.
Anything from the people?
Would the court ask the people to prepare the order for the competency?
Yes, please prepare the order for the competency if you would, sir.
And the address for,
The defendant,
I see on the complaint is 14.
is that your address, sir?
Excuse me. That's correct.
All right, very good.
And so I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry. Can I get that date again, please, sir? If I can put it in my calendar.
July 25th, you were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I
the
did.
court.
I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it. I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before today?
Well, as I stated at the last hearing,
No, don't go through what you
additional week.
stated at the last hearing.
Well, you
You
asked.
knew that, no, you knew it was supposed to be filed before the day. Young man, you're gonna
That's it.
figure out something. We're playing by my rules, not yours. So you know, do not say anything because you're gonna figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending in for a competency, I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go. What?
I didn't get the last part that you said. The bond continued and what?
I said you can go.
Oh, okay. No problem.
Is that it for me? Thank you, Ann. Thank you, Alan. Thank you, Em. Court, say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court. No, my turn. The case, the very first case, when you say the first case I called today was upon receiving a notification about something that I had considered in a bond was notified that that had been located, this court, to the defendant's benefit, set that hearing without notice to any side. I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow. Happy. All right. Court does call the case, People of the State of Michigan versus James Whitley.
Your Honor, for the record, my name is Jeffrey Dunn, attorney with Mr. Whitley, standing to the right, sir, please state your name. James Thomas Whitley.
This is a continuation of the hearing. Is there anything additional from the people?
Nothing additional from the people here.
Anything additional from the defense?
Nothing, yes, Your Honor. One thing additional is that if the court finds that money bail is necessary, I believe that based on this case, the appropriate bail would be something like a $10,000. The current bond conditions regarding specifically a GPS tether with the exclusion zone and the drug and alcohol testing, I think, address what the primary concerns are in the report. He was intoxicated, and of course, he should not be around here. But the reason I think primarily that the $150,000 insurance bond is excessive is that he has no history of any violence whatsoever. In fact,
Well, can I just stop you there? Because I have some concerns about the representations of what happened that were made to the magistrate at the time, and some of them made to me yesterday. I went back and listened to the arraignment. And my understanding is that the alleged victim in this case contacted the defendant to pick her up from Chelsea bowling lanes or something along those lines.
he went to Chelsea Lanes to make sure she got home safe, because she was intoxicated.
Right. And then after that is when this ensued. I'm having difficulty, well, let's put it this way. According to what I have, he shouldn't have been driving. That's number
Well, he
one.
wasn't tested. The allegation is that he was intoxicated. I don't believe he agrees with that characterization.
Mr. Bennett, do you know what you said at that hearing regarding intoxication? Well, first of all, I don't think there are two issues there. One, he wasn't supposed, my understanding is his license is revoked with restrictions. And that his activities in going there that night would not have been within his restrictions on his license,
Okay.
right? Secondly, with regard to the incident, the indication is he was trying to get his keys to then drive again, which would have been outside of his restrictions on his license. And there was at least the indication when there was a talk of intoxication that the defendant at that time may have been intoxicated.
I believe I said exactly that. He may have been intoxicated. Can I address that concern or not?
Go ahead.
Your Honor, if that's the concern is that he was driving with this habit, then, an added condition of he can't be driving without a valid license.
No. My problem is with the whole story. Because why is he getting his keys to drive when he's not supposed to be driving? Is what I'm having difficulty even understanding the events as you're telling me they may have existed at that time.
She was intoxicated at Chelsea Lanes. He went to try to drive her home. She refused. She drove her cell phone. I haven't seen the alcohol test. I don't know whether that's intoxicated or not. He followed her home to make sure she got there okay. The parties, he had generally, I believe, according to the report, spent most nights there. Then they got into an argument and he tried to leave, couldn't find his keys, and that's when the incident with the bed, the phone, and the glass break began. I think, in my opinion, those sort of discrepancies are only, I guess, the absolute truth, I guess, would be relevant to the bond, but they decrease the likelihood of conviction when you have the alleged victim saying that her statements were entirely accurate, and wishing to recant, and him saying he was looking out for her. When the argument got loud, he had asked her to keep it down so her children wouldn't hear them arguing, because he was concerned about trauma they experienced from a prior abusive relationship. And telling her to calm down actually escalated the fight, and that's when the incident happened in the bedroom, which there's a disagreement about what that was. That, at the end of the day, resulted in the injuries that were sustained by the alleged victim to her wrists, our arms, and a head. I would clear up, since you gave me a chance, there were actually, I believe the people said there were 3 CAT scans, there were 4, there were 3 x-rays. I was able to do what they provided. But I think that the key issue in this bond is somebody who is a close friend, the alleged victim, has known Mr. Whitley for 20 years and said he's not violent, that this has never happened. So, regardless of whether or not there's a conviction for purposes of bond, he does not pose.
Well, if I consider him a danger, yes. I mean, what I've got here is I've got somebody that shouldn't be driving, who may have been intoxicated, who would have driven on 2 occasions when he's not supposed to be driving, in violation of his restricted license breaking law. Then I have this confusion about the incident. I don't even know why she would have his keys if it now, as you're relating to me, that he drove and then followed her, which was not the indication that I got from listening to the arraignment. And then an altercation occurs that results in what I would consider significant injuries to the alleged victim in this case, to the point of a level of medical care that was required regarding that person, which I think would have been significant. And then from that, does she have to keep moving?
Risk outweighs sympathy.
And then, it creates in this court's mind a level of potential danger that this individual poses, potentially to the victim as well as to the community. It certainly raises that level because he's not this law-abiding person that you say he is, because he's obviously driving. I mean, he's got those previous convictions, which led to the revocation of his license, which led to the restriction, and he's violating that twice that night, at least. So, I don't know. Sparosa, was there something else?
No, you're right.
Anything else, Mr. Bennett? Anything else, sir?
No, I just don't know. I get that he was driving when he's violating his restriction. It doesn't warrant $180,000. I do think that some cash bond is appropriate at this point. I think it should be something that policy, especially in case that the likely sentence is probation.
Understood. And what I am additionally indicating is that in listening to what was the representations at the arraignment regarding what transpired, listening to what transpired that day, hearing what is today, it's unclear to me that that's what actually happened. Because that's not what's been said on the defense side about how this whole thing comes about. I then end up with an individual that is severely injured where they're at the hospital getting the treatment that they're getting. There's some indication that that's her fault. Maybe. But then, and that the defendant is trying to get away. I just find that version of events, it may indeed be true, but I find it, at least at this point, to be sort of remarkable that that would be it. The court, go ahead. What are you going to say?
I was just going to say that could solve my testimony.
Oh, I'm sure it certainly will, but I don't have that at this. It normally would during a bond hearing. I have to assess it based upon what I see, and I would say also, with all due respect to the magistrate of this court, that making a statement of giving a PR, but then indicating that the people might file an emergency bond motion. How she'd know that, I do not know. But that, from my perspective, leads the court to believe that it was in part of the court's funding, but also as a result of what the court is looking at in this case, would find that her decision to issue a PR bond was indeed an abuse of discretion in issuing that bond. The court will leave all of the conditions that she set in place. I will set the defendant's bond in the amount of $35,000 cash surety. Defendant remanded.
Thank you, Your Honor.
Bill 1. All right. Court stands at recess. Thank you.
All right.